your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome, everybody. Today is Tuesday, which means it's Judge Simpson Day. There's ought to be some interesting cases coming up in Judge Simpson's court. Now, I won't be able to watch the chat. I need to watch the YouTube video that I'm sharing with you because I got struck for a song yesterday. So I need to be careful. I need to watch the ads. So I'm going to be doing that. But I'm still here. I mean, you know. And this whole what the hell's pain in the ass. That's why I don't talk about it on here anymore. But let's get started with today's docket. Shall we?
Yeah, a couple weeks. Yeah. Okay. That's cool. Thank you.
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those having for the court draw near, the Honorable Judge J Cedric Simpson preside.
You may be seated. Ms. Lundy.
Good morning, Your Honor. Ashley Lobby for the people. At this time, people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that any conflict exists. Make the waiver for the avoidance spelled out.
Downtown Lauren Brown. Go ahead.
Good morning, Your Honor. Downtown Lauren Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that a conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this court could hear these matters.
Thank you. And the court for its part also does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the cases of the People versus Dale Miller.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without having.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller. Mr. Miller, will you please state your name for the record?
Dale Joseph Miller.
Thank you, sir.
And we're asking for an adjournment. I do have a meeting scheduled with him tomorrow afternoon.
We need a couple weeks,
Yes,
3
please.
weeks out. 23rd will work for it.
Sure, Your Honor.
All right. Probable cause conference without objection is adjourned January 23rd, 2025, 9 a.m.
Thank you.
Bond will continue. Thank
Mr.
you,
Miller,
sir.
I'll talk with you tomorrow.
Okay, thank you.
Thank you, Your Honor and staff. Have a blessed day.
You do the same. Court does call the case of the People versus Samantha Classic.
Ready, Your Honor.
Good morning, Your Honor. Joseph Halpern on behalf of Ms. Classic, who is not going to be present today.
She's in treatment.
She is, Your Honor, and I'm sorry, Ashley. We tried to get all docs to both you and to the prosecutor. We do believe she's in a place that's good for her and for her future compliance. I spoke to Sister Counsel yesterday. We've made inroads and family members have communicated with Maple Grove. HIPAA waivers are being executed as we speak. She entered on Monday. She tested on Monday. She will be regularly testing, and one of the HIPAA waivers is going to go to community reported for obvious reasons. We have no objection to that, and these waivers should accomplish the same.
And that is correct, Your Honor. I know the court has received the progress report, which did indicate a unable or refused, then a test that was positive for THC, benzodiazepine, and cocaine, and then a missed sample on January 6th. I have no reason to doubt anything that Mr. Hall is telling me, but this is an extremely serious case. So the people would request a very short adjournment to make sure that we get all of the necessary releases sent over to community correction so that we can have assurance that she is testing and that everything is going. And we know where she is. We know that she is where she reports to be and all of those things.
No
So,
objection.
when you say a short adjournment, if she entered on Monday and you want testing, then what, 23rd or 30th?
I'll take the 23rd, please. If she's not able to attend the 23rd because she's still in treatment, people are gonna have an issue pushing it out.
I will not.
Yeah.
Sure, it's my I'm in front of Judge Turfy in person. That's in Dearborn, and I have a Zoom.
They called and said they don't want you.
I don't doubt it, Judge. Somebody's got to take me though, right? So, Your Honor, the 30th would work much better for my calendar. If
January 30th, 2025, 9 a.m. Otherwise, I won't get to everybody else today.
Thank you, Judge.
Thank you.
Appreciate it.
Court does call the case of the People versus David Furman.
Yes, Your Honor, I'm present.
Yes, sir.
Your Honor, good morning. For the record, my name is Mark Burke, P number 54935 for the Attorney General's Office of People.
All right, thank you. Who's on this? Pardon? You have Jerkus?
Right.
Furman.
Oh, Furman, Edward Drucas on behalf of, I didn't hear the name. Oh, okay. Edward Drucas on behalf of the defendant.
All right. You're requesting an adjournment?
I am. We did have a conversation yesterday. I got to reach out to the AG to try and negotiate the.
Any objection from the people?
No objection to adjournment, Judge. I didn't catch the defense attorney's name there.
I'll send you an email.
He said.
I
he'll send
emailed
it.
the other AG thinking he was on it because that was.
Okay, he'll send the email.
Okay, very
You
good.
want the 23rd or 30th?
The 30th, Your Honor.
Probable cause conference, January 30th, 2025, 9 a.m. Bond will continue. Mr. Furman, can you state your name for the record, please, sir?
David Lee Furman.
Thank you. All right, January 30th.
Thank you.
Thank you.
Thank you very much, Your Honor.
Thank you, sir. Court calls the case, People versus Russell Exelby.
And good morning again, Your Honor. Joseph Paul appearing forward on behalf of Mr. Exelby, who is approaching. Mr. Exelby, once you're here, if you could state your name for the record, please.
Russell Exelby.
Your Honor, we have submitted a green sheet in this matter as he has been screened by Ted Heaton. He did say that Ted came in and visited him. We don't have an answer yet from Ted sufficient to indicate whether he's eligible or not, which hamstrings the negotiating process. We do believe that if he is eligible, we'll both have an offer and a resolution to this matter. So we're asking for an adjournment so that we can get a response from the sobriety
You
court.
want 23rd or 30th?
30th would work better for my calendar, Judge.
Probable cause conference without objection, January 30th, 2025, 9 a.m. Bond continue.
Your Honor, regarding Bond,
Bond, yeah.
obviously, Your Honor knows about the tortured history of Bond in this case.
Yes.
Mr. Exelby is prepared to admit that, one, we acknowledge that the tether he was wearing did indicate a tampering event. He doesn't object to the fact that the tether did show the same, and he acknowledges a problem with alcohol. And he'll sit here and tell Your Honor that today. He would like to get out so we can continue getting treatment outside of the jail.
If I can shortcut this, I'm not going to consider any release until we get some assessment from the sobriety court.
Thank you, Judge.
And I'll take a look at that after council's had a look.
Understood, Your Honor.
All right.
Thank you.
So Bond will continue. Thank you.
What if you can create your own website by saying, this is what I want? You can.
Court does call the case of the People versus Melvin Langston.
Edward Drukas on behalf of Melvin Langston. He's on his way. And actually, I just received an email indicating that an attorney is going to be substituting.
That what? You received
an email indicating that he may have obtained representation.
Why isn't he here?
I received a phone call as I was walking in this morning from an attorney by the name of Quentin Knox, who says he's been retained. I replied, he sent me an email, which I replied to and CC'd your staff, just to make them aware. But I have no idea if he's planning on attending or not.
I was on the phone about 15 minutes ago. He said he'd be here by 9:30. So I'm assuming he's going to be
So he lied.
I'm gonna throw myself under the bus for him, Your Honor.
Well, so he's not here. Mr. Dox isn't here. Nobody's here.
I'm here, Your Honor.
Mr. Drukas and I.
So you guys aren't doing me any good. I'll pass it.
Okay, thank you.
Court calls the case, People versus, is it Methany Bentley?
Morning, Judge. Torsia, Public Defender. Appearing on behalf of Mr. Bentley. Mr. Bentley, please state your name.
Danny Bentley.
Thank you, Judge. I have had a chance to speak to my client. He's asking for a preliminary examination, please.
Pardon?
He's asking for a preliminary examination, please.
All right. All discovery is complete.
That's my understanding, Judge.
And what data we have? People have their witnesses.
It's all about discovery. And see, it seems that a certain person never failed to provide discovery in a certain case, which we normally won't talk about on here. I find it odd that she's trying to file a countersuit.
It's available to 21st.
Correct that date, Graham. Thank you.
Preliminary examination in person, January 21st, 2024, 25, 9 a.m. before Judge Moore.
Thank you very much.
Thank you, Bond. Look. Court does call the case, People versus Emerson Wilson.
After people.
Edward Lucas on behalf of Emerson Wilson.
Sorry, your name?
Emerson Wilson.
All right, what, you're requesting an adjournment?
I'm asking for an adjournment, Your Honor.
And we have a new bond violation report.
Yes, Your Honor, I'm in receipt of that. I don't know if a warrant didn't go out.
Pardon?
A warrant has not gone out on the case.
You want me to issue one?
No, Your Honor.
All right, let's address it then.
Addressing it, he does have an appointment today for a medical marijuana card. The last time I talked to him, it was you can't use until you obtain a potential card and seek that permission from the court. That didn't get done quickly. However, he does have an appointment today. He did provide me proof. We're working on negotiating a potential resolution in this case. He understands and can direct to the court that he will not use until
marijuana use in Alabama is still prohibited. It's still against the law here. But most states, it's legal if you have a card. Wow.
Has he been using? I mean, and so before you answer, understand, I don't want to call over and get levels, but I will.
Speaking with him, and he's willing to tell the court today as well, is yes, Your Honor. He's been defying the court order. He thought that him obtaining a card was enough for starting that process. But he understands now and will not be using. And I think if we go out to the 30th, the levels will be going down until he gets permission from the court.
Probable cause conference will be adjourned to January 16th, 2025, 9 a.m. This time, defendant's bond is revoked, defendant remanded. Let's call the case, People versus Sean Caldwell.
Morning, Your Honor. May it please the Honorable Court, David Burke.
Other way.
Sorry, Judge. I'm backwards this morning. Your Honor. Sorry about that. On behalf of Mr. Caldwell, who's joined us this morning.
Your name, sir?
Sean Caldwell.
All right.
Discovery is complete, Your Honor. We're asking for an exam.
People have their witnesses available the 21st? All right. Preliminary examination in person will be set January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue. Thank you. Court does call the case, People versus Maria Valenzuela.
Okay, what's the next problem?
Solve for X, where X equals better grades and more confidence.
Good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Valenzuela. Can you please state your name?
Maria Ochoa Valenzuela.
Thank you.
Your Honor, we're asking the court to please set this for a preliminary examination. Discovery is complete.
People have their witnesses available the 21st. Preliminary examination in person will be set January 21st, 2025, 9 a.m. before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Ronald Calloway.
Your Honor, good morning again. Mark Burke for the Attorney General's Office of the People.
Is he on the screen? He should be. Calloway? Easter. Where's Mr. Feaster? He's requesting an adjournment. I don't know There, Deputy.
Lloyd Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Calloway.
All right.
That's asking for an adjournment, is that correct?
No. There's a request for an adjournment. Is there any objection from the people to adjourn this matter?
No objection, Judge. The only question I have is, I'm not sure the bond is on this case, Judge.
All right. I have his bond at $3,476 cash to be paid to the friend of the court case.
Thank you very much, Your Honor. Appreciate that. No objection to the adjournment.
So, Your Honor, may we address, this is a child support case, is that correct?
It is.
Okay, so, I think the standard.
You need Mr. Feaster.
I'll need.
Okay, can somebody find Mr. Feaster, please?
Yes.
Sorry.
Ready, Judge? Portia Feaster, Assistant Public Defender on behalf of Mr. Calloway. Thank you, Judge. I have met with Mr. Calloway. I've spoken to the people on this case. My understanding, Mr. Calloway does want to waive the circuit court to get this matter resolved as quickly as possible.
Oh, so he wants to waive, so we don't need the adjournment.
No, Your
Callaway, is that a correct statement?
Yes, sir.
You understand the preliminary examination is a procedure where the people would have to show by probable cause that the offense alleged was committed?
You understand that?
Correct.
So, yes.
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yeah.
People also waive their right.
We are, Your Honor. Thank you.
Preliminary examination having been waived, defendant bound over to circuit court on a single count. Mr. Feaster.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
January 21st at 1:30 for Judge Cunkey.
January 21st, 2025, 1:30, Judge Cunkey.
Judge, my client did want me to address one issue regarding bond, if you don't mind.
Go ahead.
Thank you, Judge. I explained to my client the statutory requirements for a child support case and his bond. He wanted to make sure that his bond, to ask the court to set this bond to the lowest possible amount. I told him I thought it might be there already, but he wanted me to confirm that with the court. And if not, he wanted to have it reduced to the lowest possible amount.
His bond is set at $3,476, which would mean that he would have approximately owed somewhere in the neighborhood of, I don't know what his current obligation is.
I can let you, Your Honor. I can explain that. His current obligation right now is $15,370.58. That's as of January 6th. He has an ongoing support obligation also of $203. The defendant hasn't made a payment since August of 2023. Technically, the bond should be a little bit higher. It should be about $3,800 right now. But
Right.
but I'm not going to make an issue out of that. So
So it is the lowest possible. Thank you, Judge.
Well, it's lower than the
It's
lowest
lower.
possible.
So it's not.
Do you want me to change it?
Not at all, Judge.
Okay, then we're done with that conversation?
We are, Judge.
We are.
Thank you.
All right, bond will continue. Thank you.
thank you, Your Honor.
Court does call the case of the people versus Malik Ward.
Individual defender, we have Peter John.
Sam Bernstein for Mr. Ward, Your Honor.
Mr. Bird, can you state your name, please? Where is it? Do you have it?
Wow, they locked your ass up for child support? Yeah, I guess that's possible. $15,000 in back child support? Wow, that's a lot of dough to me.
Okay, I got it. Mr. Word, can you hear me?
Yeah, I can hear you.
Okay, can you state your name for the record, please?
Malik Ward.
Thank you.
Your Honor, we're asking for a preliminary examination date. I do believe that discovery is complete.
All right, there is an added count 5.
Yes, we can waive formal reading, Your Honor. Mr. Ward stands mute.
All right. Defendant waiving formal reading. Court will enter a not guilty plea as to count 5. And you say all discovery is complete even with reference to the added count.
Yes, Your Honor, it's all.
Would people have their witnesses available on the 21st?
Yes, Your Honor.
Preliminary examination in person will be set January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Court does call the case of the people versus Cody Turnier.
Morgan, please on for the people.
Good morning, Your Honor. Charlotte Stefan on behalf of Mr. Turnier.
Good morning, Your Honor. Marcia Krejci on behalf of Mr. Turnier. I'm here to, my motion withdraw. I mean, not my motion withdraw, but to make sure the withdrawal goes through. I have no knowledge or information regarding Mr. Turnier. I don't.
Mr. Turnier's here. Your motion is granted.
Thank you.
All right. All right. What are we doing on this case?
Your Honor, I am in need of Mr. Turnier's phone number so that I can talk to him about the.
Ms. Krejci, do you have that?
Nobody has my number, so I don't have a number. It's been very hard for me to get one.
He doesn't have one. All right.
I'll give you mine. My friend's number, the one that's been helping.
All right. You'll have to try to put that into the chat so that you don't broadcast it everywhere, and we'll get it over to council.
How do I do that?
Okay. Well, yeah. That's all right.
Sorry.
Have it? You have the friend's number?
No, I
What are you trying to hand me then?
Green sheet
Oh.
manager.
I'm not going to worry about that at this point. I got new counsel. All right. Counsel, you want this adjourned out?
What's your number?
Yes, Your Honor.
The other thing is that I won't address it today, but he may need to appear in person because I've got a violation report from Community Corrections regarding missed samples, 3 consecutive ones.
I actually had a hard time getting to these appointments.
Sir, you might want to talk to your attorney before you start addressing me on that.
Your Honor, I also believe it was positive for THC.
Yes, there was a positive for THC back on December 18th and then 3 successive misses. And prior to that, there was an unable or refuse.
I didn't.
But I keep clicking the wrong crap today.
So here's what I will do. Sir, you're going to need to arrange to be at the courthouse. We will try to get what information we can to you, counsel, so that you can contact him. But I'll adjourn this out just 1 week to the 16th.
I have a court date on that day.
Pardon?
I have a court date on the 16th at 9:30.
Where?
I'm pretty sure it's going to be at 14-2.
14-2?
Yeah.
Okay,
Yes,
we're
Your
right
Honor.
down the
I also
we're right
have
down the
a-
street.
Your Honor, I also have 2 other matters that morning. Would it be possible to adjourn 2 weeks?
Well, I think that I need to address his bond violations. Otherwise, I'll just revoke his bond. We'll come get him and then we'll set it whenever we're ready can be here. Which way do we want to do this?
Well, I understand, Your Honor. We will make arrangements to be there. I'll talk to your court clerk about. coordinating.
Fantastic.
Judge. And I
Probable
do
cause.
have Mr. Tournier's phone number from the chat. So Mr. Tournier, I'll be calling you when we hang up here.
Okay.
January 16th, 2025, 9 a.m. Bond
Thank
at
you,
this
Your
time, Bond at this time is continued. Thank you.
Thank you.
Court calls the case, People versus Alejandro Montano.
Rachel is appearing on behalf of the people.
That one. Okay, even though you already opened another court date, you being late to that, he should not lock you up before.
Good morning, Your Honor. Marcia Creature on behalf.
Your motion's granted.
Thank you.
Mr. Constantino's on this case. He's at the Bureau of Prisons and they did not sign in because of the holiday.
Federal holiday.
Today?
Yeah.
I'm out. What is, what day?
The state funeral for President Jimmy Carter.
I should not.
We were hoping that. I wasn't gonna finish that. That it was gonna be a national holiday.
How many cases does he have?
Too many. 12.
He's got like 12 cases? All right, so I got time for my shot. All right. What I'll do, why don't I, if he's in federal custody, let me adjourn it out to the 30th. Will that work for you, Counsel?
Judge, I apologize. I can't do the 30th. I could do any other Thursday, though.
Any other Thursday but the 30th? Okay, what? Oh, so just give me a date. Just give me a date, because Bellinger messed everything up. February 6th.
Don't laugh.
Bravo Cause Conference will be adjourned February 6th, 2025, 9 a.m. Bonds continue.
Give me a call on this. We may be able to resolve.
Will do. Thank you.
Thank you. Court calls the case, People versus Destiny Cheatham.
Good morning, Your Honor. Rita, Assistant Public Attorney on behalf of the people.
Good morning, Honor. Rob J. on behalf of Ms. Cheatham.
Your name?
Destiny Cheatham.
Thank you.
Judge, can we set this matter for exam, please?
All discovery is complete.
Yes, Your Honor. And this young woman has done everything you asked her to do. She, at community college, she took her GED testing on Monday. She's working now. So she's done.
So that she, what about the GED testing?
I'm sorry?
You said about the testing. Did she do that?
She did.
Yes,
You want
I
to tell-
wrote in yesterday. And I did my schedule Monday. And I started working through the states for home health care on the 1st.
Tell me about the testing.
I'm getting my results in Monday,
And when did you do it?
yesterday, the 6th.
At community college.
At community college.
Washington.
Yeah.
So you asked her to do it, she's doing it.
How'd that feel?
Good.
So we won't delay this. Can we get a date, Your Honor?
No problem with that. Will people have their witnesses available the 21st? All right. Preliminary examination will be set in person, January 21st, 2025, 9 a.m. That's before me.
Thank you, Judge. We appreciate your consideration.
All right, bond with it. It will continue. You're going to pass all of those things, right? I'm going to see that certificate at some point.
Yeah.
Judge, and maybe if she does all that, you'd consider removing the tether?
No.
Okay, thank you.
All right, thank you. Good try, Kilowald. Court calls the case, People versus Desmond Markowski Smith.
And then on behalf of the people,
Wow. Hold on. Say that again.
and then on behalf of the people.
That sounds so good. All right. Your name, sir?
Desmond Makowski Smith.
I know. He's like Mr. Magoo.
Makowski, Judge, I was just appointed on this case. Although he has a case in circuit court that I was appointed last week to, it's my understanding this young man would you consider a bond motion on this, Your Honor?
If it's a short bond motion, I'll hear it. Otherwise, if it's going to be extensive, you're going to need to put it in writing and then I'll hear it at some other time.
No, it's just very briefly, he's employed. He can be employed, Your Honor. It's my understanding, he'll obey any court order. He'll show up for the next court hearing. And I believe, speaking with him, that it'd be better off that he were out. He and I could more capable represent him.
Response.
My understanding, currently probation violation, which is bond is denied.
Is that correct?
Judge, we were in front of Judge Kuhnke yesterday. She adjourned it a week so we could make this argument today. She said if we were successful in reducing his bond today, she would strongly consider her bond denial.
But his. All right, go ahead.
Your Honor, we would still be concerned and object to any modification. He has a previous history of assault with a dangerous weapon, home invasions, misdemeanor, push drawn to the bed and his head on her foot in 6 to 8 seconds. Said, "We think this is the game." He broke through her after 2 daughters and left. And after she left, he took her keys and wallet and her purse. We would have great concern for her safety as well as.
Judge, the only comment I make is
I ain't gonna
this was from 2021. You guys have moved on, right?
Oh,
Okay.
If you have dementia, try this elephant trick tonight before going to bed. Why has no one told you?
Your Honor, I believe
This case,
this is a PR bond because this case is from 2021, Your Honor.
yeah,
Right, it's a PR bond on this case.
I was told in circuit court they had a cash bond on this. I'm sorry, Your Honor.
I have so there's no. All right. Motion modified to bond is denied. I'll leave his bond where it is. He's being held on the circuit court matter. Thank you.
Circuit court. Thank you.
What they did? Okay, I don't think I did.
You did not.
What do you want me to do with this case? Hold on, sir.
Judge, can we just set it for exam?
Are you ready?
Yeah, Judge, it's a 2021 case. I'm familiar with it. I'd like to go to exam.
Will the people have their witnesses available on the 21st?
Hey, Your Honor, can I speak?
I'd be real fortunate.
About what?
I ain't talked to, I don't even talk to Jasmine.
Welcome back, Gail. Yeah, that whole thing with the what the hells is just ridiculous. It's just it's a ridiculous mess. I don't even know what to say. This guy is another sovereign citizen like our Mr. Magoo. I think this guy's a sovereign citizen like Mr. Magoo is. Because he mentioned, Judge Simpson mentioned Mr. Magoo. Yeah, it makes my head hurt, my back hurt. Yes, it is. And it's informational how the court system really works for these criminals. Tomorrow is Judge Boyd, Judge Stephanie Boyd. And she's interesting. I like her. These judges are compassionate with people, but they don't take no crap from people. Just like this new judge with Lynette. This judge ain't going to take no shit. If she files a counterclaim, it's probably going to get denied. Because she never puts... It's a thing about discovery. She never put any discovery in. Not with Stark, BBB, or whoever, never put in any discovery in that case. That's why it was dismissed. That's why that stuff was dismissed, because she never put any discovery. That's why when you hear Judge Simpson talk about doing the preliminary hearings, he's gonna and doing the hearings, he asks, "Is all discovery complete?" I like all these judges. I have a lot of respect for them. But now I'm in and out of chat because I have to watch the ads. The Denise Williams song got caught in this live stream. I got copyrighted for it, so I had to go back and delete that little section of the video so there wouldn't be a copyright strike. So I gotta be careful. Well, I'm really trying to watch ads.
I ain't talked to deal with her in years. And this ain't even true, what she's saying.
We'll see if the exam.
Preliminary examination, January 21st, 2025, 9 a.m. That's before Judge Moore.
Good. I'll straighten out with
Bond will continue.
Thanks, Judge.
Court calls the case People versus Casey O'Neill.
Morning, Your Honor. Richard Cunningham, P29735, Assistant Attorney General on behalf of the people.
All right. Good morning.
And good morning, Your Honor. For the record, Orlando Simone Services on behalf and with Miss O'Neill, who's appearing by Zoom. Miss O'Neill, would you please unmute and state your name for the court?
Casey Lynn O'Neill.
What are we doing?
Thank you. And Your Honor, at this time, if we could set this matter for preliminary exam, discovery is complete.
Right. Would the people have their witnesses available the 21st?
Yeah, this ad was, let's hear it for the boys from Denise Williams from Footloose. I guess the record company struck it. and you hear Judge Simpson, is all discovery complete? And that's where Lionette fucked up. She didn't put any discovery in any of these cases. That's why they were dismissed. Now she's going to file a countersuit. She was going to file a countersuit. Yeah, good luck with that, Lionette. You don't have a case. You never supplied any evidence because you deleted the fucking evidence. Now, I didn't want to talk about that, but that's bullshit. What she's doing is bullshit. It really is. It's bullshit. Now she's trying to countersue. She's trying to countersue to get out of all of this. Lady, it's your fault. You did this shit. You stalked him. You harassed him. You defamed him. You did all these things to him. And I was coming back at you. Michelle, you have nobody to blame but yourself for all of this. And that's all I'm going to say about it.
Yes, Your Honor, we could.
Preliminary examination will be set in person January 21st, 2025. That at 9 a.m. That is before me.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Very well. Have a good day. Thank you, Mr. Cunningham.
Court calls the case of the people versus Kevin Chavos.
to the people.
No offense, but if you're paying more than $50 per month on home insurance, you're literally throwing money away in the trash.
Ms. Cannon?
Just setting it.
Ready, Judge. Torshio Feaster, Assistant Public Defender, standing in for Ms. Cannon. Please state your name for record, sir.
Kevin Shavoo Jr. Thank you.
My understanding is we're setting this for preliminary examination, Your Honor, and all discovery is.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you very much, Judge.
Thank you. Court calls the cases of the people versus Maurice Anthony.
During on behalf of the people.
Assistant Public Defender Chelsea Virgils on behalf of Maurice Anthony. Your Honor, it appears that
Kind of lonely up there, huh?
here today. I would ask you not to issue a bench warrant. I believe he has a court date in county this morning. I suspect that's where he may be. I do have paperwork showing that.
Well, do we know that's where he is?
I haven't talked to him this morning, but I did speak to him yesterday about how he does have that court date.
Your Honor, I was speaking with Detective Moser from EMUPD yesterday, and I think he court information. He was charged with new offense out of Waterford while this case was pending. And as a warrant out of, I know of some Waterford PD that's picked up on, or would be picked up on Hank Dungeon, as well as I think something else out of Ocean County. One for both, at least 2 felony warrants. I'd ask that a bench warrant be issued, and I'd ask for maybe $20,000.
Bench warrant will issue for defendant's failure to appear in these matters. Bond is set in the amount of $25,000 cash. Surely those warrants will issue immediate.
Wow. That's
Thank
a
you,
big
Your Honor.
bond.
Thank you.
That's what you get when you don't show up for court. A bench warrant. Don't forget that, little boys and girls.
Let's call the case of the people versus Sean Odom.
Edward Droops on behalf of Sean Odom. In the 5001. Assistant Public Defender Jay Bellinger on the case ending in 1311, I believe, Your Honor.
Oh, joy. Me. Your name, sir?
Mr. Odom.
Thank you.
Your Honor, You're in 5001, we're looking for a preliminary examination. To my knowledge, discovery is complete. Same as 1311, Your Honor.
People have their witnesses available on the 21st.
I'll do our best.
Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge, before me on both of these matters. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Emily Bates.
I know what's happening on this case. Call Bates.
Yes.
Portia Feaster, Assistant Public Defender on behalf of Ms. Bates. Ms. Bates, please take the record.
Tony Bates.
All right.
Thank you, Judge. I've had Ms. Bates in the past. I've been in contact with her father, and I've reached out to the people in this case. I was attempting to get some information from our Charlevoix County Probation Department to try to help resolve the matter here. That information did not come. Her agent was out of the office, holidays, and things of that nature. If we can have an adjournment for a couple of weeks, I'm confident I can get that information and give it to the people in hopes of getting a resolution.
Any objection from the people?
Okay.
January 30th, 2025, 9 a.m. bond continued.
Thank you, Judge.
Your Honor, may I ask you, Your Honor, I'm sorry, is it possible to get a later date, a later time? Later than
I
9?
set it at 9. Your case could be put into a later block, but council would have to make that request of us and
Have your
can
father
accommodate it, we will.
Sorry, Judge. Have your father talk. Have your father remind me, Ms. Bates, and I'll reach out to the court.
Okay, thank you so much.
Thank you.
Thank you, Judge.
Court calls case, People versus Christopher Peoples.
Your Honor, good morning again. For the record, Mark Burke for the Attorney General's Office of the People.
Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Peoples. Mr. Peoples, please state your name for the record.
Christopher Peoples.
Thank you.
Thank you, Judge. I had originally reached out to Mr. Awuda Coker. It's no longer his file, so I did not have conversation with the people on this file. We could adjourn this out for a couple of weeks and I'll talk to Mr. Burke, and hopefully we can find out where we stand.
Tight who? Tight who? But Mr. Simon did not file an appearance. All right. Sir, your name?
Harry Brennan, sir.
All right. My understanding is you were represented by Mr. Simon at the arraignment, however.
Yes, I did not attain him as my representation, and I would like to ask the court to a request for a court appointed attorney.
This is a public defender case now.
How you doing? My name is Mark. What's your name?
Harry Brennan.
So that charges are aggravated stuff.
All right. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Brennan. We respectfully request that this matter be set for a new PCC date. Okay. That way we'll have
Probable cause conference in this matter will, without objection, be adjourned January 23rd, 2025, 9 a.m. Bond continued.
Thank you so much.
Thank you.
What we're gonna do.
Court calls case People versus Benjamin Beck.
Actually, people.
Morning, Your Honor. Dan Garrett on behalf of Benjamin Beck. He's stepping forward. Your Honor, we were just retained this week. I informed the Command. I was asking for German and PCC, please, for
2 weeks.
discovery.
Hearing no objection, January 23rd, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Alfred Brown.
People. Stephanie Cannon, we have Alfred Brown.
Brown here.
No, Your Honor, I'm not sure why he's not here because we've spoken. He knows the case is being adjourned. There he is. Okay, I was like, I did speak to him, Your Honor. Mr. Brown, could you please state your name for the record?
Alfred Bishop Brown III.
All right. You're requesting an adjournment?
Yes, Your Honor, for some additional investigation. That is correct. I'm requesting 30-day adjournment because once I'm going to send my investigator out. I believe that after that happens, the prosecutor's probably going to want to send somebody out as well.
Or not? Any objection to the adjournment?
No, Your Honor.
February 6th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Thank you.
You need him.
Court calls the case People versus Robin Finney.
Rachel, this is on behalf of the People.
Morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender J Bellinger.
Under supervision of who?
J Bellinger.
Are you allowed to pick another?
Chief Deputy Lauren Brown.
Okay, that works. Okay. So your motion granted. just threw you under the bus. She said, I got business to do. All right. I have before me a plea form. Could you state your name, please?
Yes, Robin Lee Finney.
Thank you. I have a plea form before me that indicates that the defendant would be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's further agreement. It's okay to seek 7411 on the matter.
That's correct.
Yep, that's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Robin Lee Finney.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance, that being cocaine. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes,
And you also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
yes,
Still wish to plead guilty?
yes.
And to that charge, how do you plead?
But plead guilty, Your Honor.
All right. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Excuse me?
You signed an advice of rights form?
Yes, Your Honor.
All right. Any question regarding those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Oh, yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
May 28, 2024, at the location of 229 West Michigan Avenue, City of Ypsilanti, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, I have.
Did you know what you were using was cocaine?
I did.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be January 22nd, 2025, 11 a.m. before Judge Barr. Bond in this matter will continue.
Thank you, Your Honor.
Thank you.
And for the record, Your Honor, I was hoping we would have court today.
Pardon?
I was hoping we would have court today and we wouldn't be off for the holiday.
Oh, thank you. That is so nice of you. That is so nice. You stay with Lauren Brown and don't even talk to Bellinger. You're doing so well. Not only did she throw him under the bus with the Brown thing, she like backed up and kept running over me. I love it. Court calls the case, People versus Frank Cheney.
Americans with $10,000, $20,000, or $30,000 plus in credit card or other types of unsecured debt are actually becoming debt-free.
We'll talk later.
No, you know what, Bellinger, leave her alone. All right, go ahead.
Ryan Bowling on behalf of Mr. Cheney. Can you state your name for the record?
Frank Cheney.
Thank you, sir.
Your Honor, there's a waiver form before the
Yes,
court.
sir. You're waiving your right to a preliminary examination? You understand a preliminary examination is where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you will not have that hearing, you'll circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count.
Your Honor, acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for February 27, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Court does call the case of the People versus Gerald Childs. Yeah, I'm sorry.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
And good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Childs. And then say your name, please.
Your name, sir?
Gerald Childs.
Thank you.
Remember, today is the time and date set for the probable cause conference, and it is my understanding that it's going to be a waiver. I've been in touch with Mr. Bernstein, and we've been talking about a resolution that will include count 1, sexual conduct in the first degree, count 2, the GBH, count 3, the FTD, and count 4, the larceny from a person. We do not have an agreement at this time. So the waiver will be on those 4 counts with an added count 5 of criminal sexual conduct in the first degree and an added count 6 of criminal sexual conduct in the first degree.
So count 5 and 6 of CSC 1.
Correct. And the PAT code for the added counts is 750.520B. It's a multiple variable. It'll read exactly as count 1 that the defendant did engage in sexual penetration with Audrey Sharon under the following circumstances during the commission of the felony of assault by strangulation and or defendant aided and abetted one another and effective sexual penetration through force or coercion and or defendant effective sexual penetration through force or coercion and the victim sustained personal injury. With the same penalty, life offense.
So he's going to be bound over on 6 counts.
That's right.
Is that correct? And, all right, very good.
And if the case does proceed to trial, it would be on all 6 counts, we will not remand for a preliminary exam. But the plea negotiations will involve counts 1 through 4. If we don't reach a plea and go to trial, it will be on 1, 2, 3, 4, 5, and 6.
That's your understanding, Mr. Rich?
Yes, Your Honor, we have the raw workings of a deal. It'll eventually be a plea involving just that 1 count. The 2 additional counts will be dismissed later. If we go to trial, they will be present though. So we understand that.
All right. Sir, you're waiving your right to preliminary examination?
Yes, sir.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Sir.
Okay. And you understand you will not have that hearing and that you're proceeding to circuit court for further resolution?
Yes, sir.
All right. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, and the added counts 5 and 6.
Your Honor,
I'm sorry, for the waiver, Your Honor, could you just indicate what the penalties are on counts 1, 5, and 6 for the defendant?
On counts what? Counts 5 and 6?
1, 5, and 6.
Yeah, I did indicate, I think it was indicated that the 5 and 6 certainly were indicated. You understand that those are life offenses, sir?
Yes.
All right.
Thank you.
we understand and waive any further reading, Your Honor. Mr. Child stands mute, and sure Ms. Reiser will send me an amended information.
Pending and waive formal reading, standing mute to all 6 counts. Court will enter a not guilty plea. Pretrial will be set for. Said 21st.
Yes.
January 21st, 2025, 1:30, Judge Conkey. Bond as denied will continue.
Thank you, Your Honor.
Court does call the case, People versus Stephen Crawford.
We've been using IXL for as long as my kids have been in school as just a supplement.
Assistant Public Defender Jay Bellinger on behalf of Mr. Crawford.
Your name, sir?
Stephen Crawford.
Thank you. You're requesting a 4-week adjournment regarding treatment.
We are, Your Honor. We are trying to work out a resolution on this. It's going to require some time in order to look at some stuff.
Probable cause conference, February 6th.
Thank you. We also may be sending a stipulated, if I can confirm with the court, if there's a no contact order on this matter, we'll send a stipulated order if we agree on that to the court afterwards. I just want to confirm that there is one.
Regarding a Samantha?
Yes.
All right, there is.
All right, thank you.
So probable cause conference, February 6th, 2025, 9 a.m. without objection. Bond will continue. Thank you.
Thank you.
All right. Do your homework. Court does call the case, People versus Nikita Franklin.
Assistant Public Defender Jay Bellinger on behalf of Nikita Franklin, who approaches. Mr. Franklin, can you state your name for the record?
Thank you. Thank you, sir.
Thank you, Your Honor. Your Honor, we are asking to set this matter for preliminary examination, and we are also asking to make a quick bond argument,
All discovery is complete.
as far as we know it to be.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Okay.
As to bond.
As to bond, Your Honor, I have spoken with my client. He advises that he can live at a location that the complaining witness does not live at. He's willing to do home confinement, GPS tether. He works for AATA in maintenance. He's been working there for a year now. He's not wanting to lose that source of income. He just had a child. He also has a daughter who just unfortunately broke both of her legs in a playground incident, who's got some pretty bad medical needs right now that he'd like to get out and be able to take care of. So I'm asking for his release on maximally home confinement. I'm just asking that he be able to have an opportunity to be out. He's, like I said, he's willing to do GPS tether and any other conditions as set by the court.
Response.
Your Honor, in this case, the people originally requested a $200,000 bond, and we would have great concerns on who would object any bond modification. In this case, on probation present in the 22nd Circuit Court until March 28, 2025 for an RNO, ammo possession by a felon, and weapon possession by a felon. He also has previous home invasions, breaking and entering, OWI. And in this case specifically, when the victim got to an argument, he got upset. He then strangled him with both hands, and their children were present for the incident. And then after he left from the first incident, he came back. At the time of this incident, she was also pregnant. He was upset about the pregnancy. So give that objection to any modification.
And you're indicating he was on bond at the time of this incident?
I believe he was on probation.
On probation, I'm
He was
sorry.
on probation current.
And was he on at the time that this offense occurred?
Yes, Your Honor.
All right. Anything else?
We would just provide to the court that those are just allegations at this time, Your Honor.
Motion for bond reduction is denied. Bond will continue. Thank you. You got something? Thank you. Court calls the case, People versus Antonio Kraut.
And good morning, Your Honor. Assistant Public Defender Shannon Carey. I can really, on behalf of Mr. Antonio Kraut, who's approaching. Mr. Kraut, state your name for the record.
Antonio
Please.
Kraut. You need to take your hands out of your pockets.
Sorry, sir.
All right. Go ahead. What do
Judge
we
would
do?
like to set this matter for preliminary examination.
All discovery is complete.
To my knowledge, Judge.
People, other witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. Bond will continue. Oh, welcome back. I'm just. Him and Bellinger are gonna have a day. Court calls the case, People versus Brady Peterson.
Morning, Your Honor. James Fifelski, standing in for counsel of record on behalf of Mr. Peterson. State your name, please, sir.
Brady Peterson. You have any objection to Mr. Fifelski standing in?
No.
All right, thank you.
Your Honor, we would like to keep this on for preliminary exam at the next
Is
available
all
date.
discovery complete?
I believe it is, Your Honor. Also like to argue bond if I could.
Well, folks, as we've been talking about, there's an enormous amount of bad news happening in the world. Obviously,
The people have their witnesses available the 21st.
Hey, John.
Preliminary examination in person will be set January 21st, 2025, 9 a.m. before me. As to bond.
Your Honor, as to bond, it's my understanding bond is currently set at $150,000 cash, maybe surety. It seems pretty high given the fact that these are 10-year felonies. My understanding is that Mr. Peterson does not have any adult felony convictions. He has been gainfully employed at Blue Star Demolition in Macomb County, where essentially has been raised in Macomb County. So minimal contacts in Washtenaw County. Understand he has not had any contact with the complaining witness since October 15th and has had no reason to. They broke up. They haven't had any communications. So he really has no reason to be in this county but for the court proceedings, and otherwise has a resident with his aunt, I believe.
Yes.
In Clinton Township that he'd be able to either be tethered to or home confinement with work. Some way, Your Honor, that can, I believe, assure the court that though he won't have any contact with the complaining witness and he will continue to appear for court proceedings. And lastly, he also has 2 children. One is a stepson that he has joint custody over and cares for him back at home in Clinton Township. He also has a 6-year-old son who passed away last year unexpectedly from a rare heart disease. So I think he is a good-hearted family man that will take these court proceedings seriously. Just ask for a significant bond reduction so that he can post something reasonable.
Response.
So we requested 250,000 cash or surety. I understand that it was set at 150,000 cash or surety in this matter, but that's still lower than what we asked for. There were 2 counts of strangulation because, to our knowledge, there were 2 counts of strangulation that occurred over a time span. The defendant also has 3 holds, one out of Buena Vista Township for $15,000, a hold out of Davidson Township for $100, and a hold out of Clinton Township for $10,000, 10%. He has a lengthy criminal history dating back to 2010 with a juvenile adjudication for armed robbery. He also has 2 convictions for DV second and R&O, and interfering with the crime report, maluse, obstruction by disguise, as well as numerous dismissed DVs. In this particular case, the police were contacted for a welfare check by the victim's mom, because despite the fact that the victim and the defendant were broken up, the defendant had been sending out sexually explicit material of the victim to other parties, including the victim's mother. When law enforcement contacted the victim, it was only then that she disclosed these acts of violence that occurred over the span of 2 months. These particular incidents are 10-year felonies, but they are rather severe strangulations. The victim in one incident described the strangulation by being lifted off of the ground by the neck with both hands. She ended up on her back on the floor where she continued to be strangled to the point of almost losing consciousness, describing it as if she was seeing stars. She had photos documenting this with large bruising on both sides of her neck, consistent with fingers ripping. The fact that there was continued conduct after the breakup makes me concerned that the fact that they're separated is not the conclusion of this and is not the end of the threat that to the victim. I don't think that any reduction below 150,000 at this time is appropriate.
Your Honor, I would just respond by stating something like a tether or even home confinement in Macomb County, which is at least an hour away from Washtenaw County, would be significant to protect not only the complaining witness, but the community. And I don't think otherwise, with strong community ties in Macomb County, my client is a flight risk to fail to his obligations to this court. The details of the case can be dealt with at preliminary exam, and I can't speak to that other than the fact that I think 150,000 is excessive given the fact that these are not capital or more serious felony offenses.
Motion for bond reduction is denied for police and bond is set as is appropriate. Thank you.
Thank you, Your Honor. Have a good day.
Court does call the case People versus Jarrell Davis.
Action on it, people.
Assistant Public Defender Chelsea Vergils. I believe Mr. Davis.
You're just having a rough day, aren't you? Huh? I mean, you come up here twice, you don't have a client.
No, I'm.
Do you? No, I'm feeling bad for you.
It's all great. Mr. Davis is.
Oh, your client's here. See, I knew it. I had faith.
Thank you.
I was just stalling for time for him to get up here. All right, go ahead, Ken.
Your Honor, we have provided a plea form.
Yes.
Mr. Davis would like to take the offer to plead guilty to controlled substance use.
All right.
Your Honor, to be clear, that is use of methamphetamine, which does have a different PAC code than use of controlled substance, which we do use in many other pleas. That is MCL 333740428. That's use of methamphetamine, which is a 1-year misdemeanor and or $2,000 fine. Upon successful plea to that, count 1, possession of methamphetamine, 10-year felony, dismissed, no delay, no deferred, no exception for letters.
That's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Let's have him sworn.
Right here. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name. Drew Davis.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B district court.
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Say it again.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Okay, if there's one AI site builder you need to meet, it's this dope tech from Wix.
Yes.
And of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense? On the date of August 6, 2022, at the location of Parkwood Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Did you know you had it?
No idea. Yes. No. No.
Okay, you had methamphetamine in your possession.
Yes. Yes.
Had you used it?
Yes.
Did you know what you were using was a methamphetamine?
Yes.
You did?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
I'm satisfied.
Defense is satisfied.
Court will accept the defendant's plea to guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. with Judge Washington.
February 13, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court does call the case of the people versus Martin Graham.
Brian Bowling on behalf of Mr. Graham. Just state your name for the record. Your Honor, we're requesting this matter be set for an exam. I believe the discovery to be complete.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case of the people versus Kyle Rainey.
Special one for people. Assistant Public Defender, really, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Okay. Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but it to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing.
No, not serious.
Okay. He is, Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to go. Okay. He indicated that he was
You
only
need to take your hands out of your pockets.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield.
Litchfield, Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
I didn't think I'd ever say this, but credit card debt was running my life. Then I found national debt relief and things finally.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact. And I apologize.
No, you didn't contact everybody you could have contacted. Did you get a response? Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else. He was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not. But the issue is he's on bond for CCW at the time of this possession case. He leaves the state, and I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are really had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was going to follow the bond conditions that were set by this court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to Community Corrections. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's order. It's really simple. Anything else?
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendants remanded on the warrant. Give me the correction for violation of his bond.
Thank you, Your Honor.
Court calls the case, People versus Desiree Badnovich.
Yep, right here.
Okay, hello.
John Rob Chico on behalf of Ms. Bogdanovich. Judge, we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms. Bogdanovich, no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they
I
told
mean,
me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
All right, so probable cause conference, I'll adjourn it. I have to go 2 weeks out. I would put it 1 week out, but we have to do the whole writ procedure to get you before me. So I'll go to the 23rd, the next day that I can possibly do it.
That's fine, Judge.
2025 at 9. Bond in this case will continue.
Thank you.
Okay, thank you, ma'am.
Thank you.
Court calls the case of People versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the
Your Honor, James Thomas for Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just to let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point,
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up. But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, sir.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or my staff.
I suggest we set an exam date.
It's not gonna happen until discovery is all complete. He's saying discovery's not, I'm not gonna do it. What I'm gonna do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not gonna set it. I'm gonna hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode protected.
And then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's gonna happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
I didn't say that.
Well, is there other notices out there for anything else that you're doing with other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. That's what I'm hearing. Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th. First case, People versus Tariq Day. Hey, guys, hold it, folks. Hold on a moment.
No offense, but if you're paying more than $50 per month on home insurance, you're literally throwing money away in the trash.
Who's who with, is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then, folks, if you would be patient, once they've cleared, then those folks can. Thank you. Court does call the case of People versus Tariq Day.
Brian Bowling on behalf of Mr. Day. Mr. Day, are you present? Your Honor, I've called his name numerous times this morning. I was unable to reach him in advance of today.
Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety.
Ooh.
That warrant will issue immediately. Thank you.
Ouch. 10 grand.
Court calls case People versus Marcel Stager.
Andrew Children's attorney on behalf of the people.
Good morning again, Your Honor. May it please the Honorable Court. David Burgess on behalf of Marcel Steger. Your Honor, discovery is complete in this matter. We are requesting exam date. I believe. Go ahead. Sorry.
Steger's co-defendant to Mr. Word, Malik Word, who we called earlier, and we set that for the 21st, I believe, Your Honor.
That's correct, Your Honor.
It was with Judge Moore.
Okay.
Yeah, that's correct, Your Honor. I was just gonna make sure the date was the same.
All right. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Thank you. See you. Bond continued. They, can you, could one of you just, oh, I see the trooper back there, but one of you check just to make sure they cleared, and then I'll release that. Pardon? It's empty, they're cleared. Okay, you folks can go ahead. Thank you for your patience. Court does call the case, People of the State of Michigan versus Kellen Dixon.
Andrew Children's attorney on behalf of the people.
Kellen Dixon.
He didn't hear you. You did not, Judge. Apologies. Wait, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Dixon. Mr. Dixon, please state your name for the record.
Kellen Dixon. Thank you.
Thank you, Judge. I spoke to Mr. Dixon. I understand from the notes he has been working to try to resolve the matter. He has asked that I set this matter for preliminary examination to try to get it moving forward, Your Honor.
All discoveries complete.
That's my understanding, Your Honor.
People have their witnesses available the 21st.
We go 1 week past that.
Any objection?
No, Your Honor.
Preliminary examination will be set January 28th, 2025, 9 a.m. in person before Judge Washington.
Judge, I'm sorry. My client just informed me he has a court date in Flint on that day.
February 4th work for everybody?
Yes, Judge. That's fine.
February 4th, 2025, 9 a.m. before Judge Freshour.
Thank you, Judge. February 4th.
Bond will continue.
Let's call the office. Thank you, Judge.
Thank you. Court calls the case. People versus Ontario Woods.
Mr. Lister, on behalf of the people.
Morning, Mayor. Edward Richardson on behalf of Ontario Woods.
Ontario Woods.
Your Honor, we'd like to set this for a preliminary examination.
All right, there is an added count for us. Let's do the arraignment on that.
Stand mute, waive reading.
All right.
Mr. Woods is the third co-defendant, Mr. Steger.
Hey, Linda, what's going on?
Got it. All right, so he's being arraigned on count 4. Should mute to those charges. All right, null discovery to your knowledge.
To my knowledge, it's complete.
And so we would be setting this one on the 21st. So preliminary examination in person, January 21st, 2025, 9 a.m. That's before Moore, correct?
Yes.
Before Judge Moore. Bond will continue.
Thank you.
Thank you. Court calls case People versus Jaden Dodge.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without having to go to court or pay expensive.
Testimony for the people.
Stephanie Cannon, we have Mr. Dodge who's appearing by Zoom. Mr. Dodge, could you please state your name for the record?
Hi, my name is Jaden Dodge. Thank you. What are we doing?
Your Honor, my client would like to exercise his right for a preliminary exam. I do believe all discovery has been provided.
People have their witnesses available the 21st.
Please, could we please go 1 week further on that now?
Any objection to that?
No objection, Your Honor.
Preliminary examination, January 21st, 2028, 2025, 9 a.m. in person before Judge Washington.
That was January 28, 2025, Judge Washington.
Yes, ma'am.
Thank you.
Bond will continue.
Thank you, Your Honor.
Court calls case People versus Michael Harris.
Good morning. We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender Quinn Withen, on behalf of Mr. Michael Harris. Mr. Harris, please state your name for the record.
Michael Harris.
All right, go ahead. Today's the time set for a probable cause conference and a bond violation hearing. With respect to the probable cause conference, we are respectfully requesting that this matter be set for preliminary examination. First available date. We do believe that we have all of the discovery.
What?
That we have all of the discovery.
All right. And as to the bond violation?
Your Honor, my client is pleading, like to be heard on that, because we'd like to address the bond. So I think in order to address the bond, you want to address the bond violation.
Say again, I'm sorry.
So he'd like to address this bond. And then I think in order to address the bond, you have to address the bond violation. So in brief, the bond violation here is that he had contact with the complaining witness in this matter. He was found in a vehicle. He's driving a vehicle. She was also, I've had a chance to speak with my client. He told me that the reason that he was in that vehicle is that he was taking the complaining witness to the hospital. Basically, they really don't have anybody but each other around here. He knew there was not supposed to be any contact. She came and picked him up. She complained that she had serious back issues and she was going to the hospital. She needed him.
Is there any medical that you have to go along with that? Or
he would not have it. He was stopped on the way to the hospital. The police arrested him. She did inform him that she informed the police, at least from what I know, that she had the back issues, that she needed to go to the hospital, and he was taking her.
She was taken there?
He was taking her there. I don't know if she went. He was gone. He wasn't able to get follow up, and HIPAA won't allow us to do any follow up.
All right. Well, here's what I'm going to do. Would the people have their witnesses available the 21st? I'll set his preliminary examination January 21st, 2025, 9 a.m. before me. I'll let you go ahead and argue bond. I'm unlikely to do anything because it's a violation and I would need some.
So yes, I understand that. We absolutely understand. I talked to him about it. He would like to have the bond reinstated, even if the court wanted to up the level to a tether or something. But once you hear the bond, the issue on the bond violation, you understand why he did it. And it was in the.
No, I get why you're saying that. And I have the report, so I see some of that. But what I don't have is the other piece to it.
Right. I know. I understand what you're saying.
Okay. So here's what I do. I'll say no at this time. Do the people know whether or not you have any information regarding the alleged victim in this case actually making it to the hospital and some documentation there? Okay. Do you know whether or not the alleged victim is saying that also, or no? Do we know?
Oh, she's here.
Oh, she is? Oh, okay. So, ma'am, I'll just ask you this. I don't need to know specific details of anything. Did you make it to the hospital? Yes? Okay, I'm gonna need some medical documentation. You can black out whatever you need to, but the fact that she went there, I need documentation of that. And then I certainly, Mr. Brown, will reconsider his bond at the time that I received that. So she needs to get that from the hospital, that she was there. I mean, even discharge paperwork will do for that purpose, but it's got to go to the prosecutor, to defense counsel, and then I can make my decision on things. Okay? So at this time, I'll deny the bond. I'll have it set. They can get that to me at any point. They can get it to me.
Yes, I love this game.
iExcel is actually a learning app that helps them excel at
Or what's he trying to read now? All right. So at this point, his bond will continue. All right. Get that. Okay.
Thank you.
Get that. Okay.
Thank you, Your Honor.
Thank you. Court calls case of People versus London Daughtry. I guess it is Daughtry.
Good judge. Floor shall please for on behalf of Mr. Doctor. Sorry. Doctor, state your name for the record.
London Daughtry.
The Daughtry, apologies, Judge. I believe you should have a green sheet in the file.
I do.
Okay. This is the first pretrial on both of the PCCs on both of these files, Your Honor. Going to talk to the people about trying to get a global resolution on them, Your Honor.
January 30th, 2025, 9 a.m. bond continues.
Thank you, Judge. January 30th. That's your next date, except for 9 a.m.
Oh, really?
Thank you, Judge. I'll write some down.
Who has to be in front of one?
Mr. Docket's, who is the one who's, Jax is supposed to be coming in.
Is Langston here?
Yes, he is.
The defendant's here?
Yes.
Court does recall the case of the People versus Melvin Langston.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Edward Dukas on behalf of Melvin Langston, who is approaching.
Your name?
Your Honor, I was asking for an adjournment for further negotiations. It does sound like as of this morning, he has obtained counsel. I haven't signed a substitution or had that attorney reach out to me yet. I would be ready at the next hearing if that attorney.
All right. Sir, you need to be here on time. You understand that?
Yes, sir. So I'd ask for just a 1 week adjournment.
Just one?
Well,
I'm going to go two.
Two would work.
January 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you.
Thank you.
Lucky you didn't get a contempt of court.
Court calls case People versus Stephen Hensel.
Ashley Lonnie for the people.
Assistant Public Defender J Bellinger on behalf of Mr. Hensel, who approaches, Your Honor.
That guy is lucky he didn't get thrown in jail on a bench warrant for not appearing on time. Usually Judge Simpson slaps him with a bench warrant.
Mr. Hensel, can you put the record?
Stephen James Hensel.
Thank you.
Thank you. Your Honor, I have checked with my office on a mitigation that we've started several weeks ago. I think the holidays kind of held that up. I have no choice but to ask for an adjournment for that reason so that we can get that in over to the prosecution for consideration on an offer. I would also like to ask to address bond briefly.
Okay, how much time are you gonna need to try to complete the mitigation?
The mitigation, I believe, is already completed. It's just going through the editing process for the final draft. So I'm just going to ask for 2 weeks.
All right, but is that gonna be enough time to get that there, have them review it, and then have meaningful discussion? That's all
I think so, Your Honor. I try to work rather quickly in cases in custodies.
Probable cause conference will be adjourned then to 23rd, 2025, 9 a.m. All right,
As to bond, Your Honor.
briefly.
Thank you. I have spoken with Emily Kenders from the CMH. She has informed me that Mr. Hensel is agreeable to start services with community and mental health on the outside upon his release. He's really interested in therapy. He is engaged with CMH inside the jail. However, it's my understanding that he's not interested in starting on medications within the jail because he's had an experience where he's been over-medicated in the past. So we would be asking for his release on PR bond today so that he can start those services with community and mental health. As I stated, he is already with services in CMH as it stands.
Any response from the people?
You know, I have the same concerns I've been expressing all along. I can understand that a person may have resistance to medication, had a previous bad experience with medication. However, one of the biggest things that we see is that folks who require mental health or drug treatment don't dictate the terms of their mental health or drug treatment. They are
Big ideas.
in a lot of ways are asked to trust experts with what needs to happen with them. So the concern of the people is that the behaviors will continue on the outside like they did before, and that there will not be adequate protections for the safety of the community if the defendant is not receiving all the treatment that his care providers deem necessary.
All right, so just based upon what is said, and I still have the similar issues I think that I've expressed before. So
If I may,
the problem is going to be that what you said is it's almost an incongruent statement saying, I understand what may be the fear over medication, but then not having a willingness to start treatment while in custody. Yeah.
presently, I'm not symptomatic. I've been stable for months, and in October, when reviewed by the Center for Forensic Psychology, if you look at the report, there was no indication of any problematic symptoms. I was actually deemed pretty intelligent and understanding of what was going on. And I'm productive in here. I've been reading textbooks. I've been doing pretty high quality art, if I may. And I would say that the concerns of the people are noted, but I don't think it's necessary. I've never had homophobic slurs thrown at me. I've never had somebody threaten to cut my throat, and that's happened to me in here. And I would say I'd be safer on the outside.
So for those reasons, Your Honor, again, we would refresh our request and asking for bond for him.
I'm going to deny the request at this time. I mean, I'm going to have something in place. I think I've indicated that, Mr. Bellinger, and maybe once the mitigation gets through, right? I mean, I don't have a problem with release, but it's going to be under some structure and so that maybe you can explain this to your client and you can hear me clearly. It's going to be on the terms dictated by those professionals, not his terms, and then also the court's terms. That's how a release will happen.
Understood, Your Honor.
So at this time, bond is denied.
Thank you.
Bond. Both for bond. Thanks. Court calls case People versus Gregory Douglas. This is my last.
Yes.
Okay.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Douglas, who should be appearing via Zoom. Your Honor.
You think it may be? Okay. Gregory Douglas? Is that you?
Speaking, sir.
All
Speaking.
right.
You got? Am I here?
We can hear you now,
We
sir.
can hear you.
Thank you, Your
All
Honor.
right. I have a plea for that indicates he's going to plead guilty to the charge of larceny 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count one would be dismissed. I noticed one problem here. The larceny 200 to 1,000 should be 1 year at $2,000 fine plus court costs like that.
I'm so sorry. Remind me, I apologize for that mistake on the plea form.
All right. And then there is an agreement of no delayed or deferred. All right, although I can't find the sentencing judge, but all right. That's correct understanding.
That is correct. I will inform the court, because Mr. Douglas is on Zoom. I did provide him with an advice of rights form via email. We did review that and discuss his rights regarding this. I also discussed with him a sentencing judge waiver, and he would waive his right to a sentencing judge.
All right.
And it is a no contest plea.
It's a no contest.
Yes.
There it is. All right. Sir, please raise your right hand. Do you solemnly affirm testimony? It will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. I do swear.
All right. State your name again for the record.
Gregory Douglas.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
I do understand.
All right. Do you understand what a no contest plea is?
I do understand, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
I do understand that.
All right. Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
I do understand that, Your Honor.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Valvo in the 15th District Court.
We are gathered here today to discuss matters of national importance and to reaffirm our commitment.
I understand, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. So understanding all of that, to the charge of larceny 200 to 1,000, how do you plead?
No contest, Your Honor.
All right. You understand that by pleading no contest, you'll not have a trial of any kind.
I understand, Your Honor.
All right. Because of that, and you reviewed an advice of rights form, is that correct?
I did, Your Honor, this morning.
All right. Did you have any questions regarding any of those rights?
I do not, Your Honor. I understand fully.
All right. And you understand that you'll be giving up specifically those rights. Well, you'll be giving up all of the rights on that form, but specifically the rights contained in paragraph 5 on that form.
Correct, Your Honor.
All right. You understand you're giving up your right to appeal of right.
I understand that. I'm giving up my right to appeal. I understand.
Well, appeal of right. You understand that?
I understand, Your Honor, fully.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, no one has threatened me.
You're doing this voluntarily?
I am doing it voluntarily, yes, Your Honor.
And of your own free will?
Yes, Your Honor.
Court has been provided and is reviewing the Ann Arbor Police Department report for their case number 23-40790. Any objection to the court reviewing that?
No, Your Honor.
No, Your Honor.
Based upon a review of the report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of this offense. You're taking it to the higher charge also because of the value issue. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea Of no contest, 2 count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
February 6th at 1:30 before Judge Bravo.
February 6, 2025. 1:30. 1:30 before Judge Valvo. Bond will continue.
Thank you very much, Your Honor.
Thank you.
If you're interested, if
Who gave
brownies,
Lauren Brown? Who's the messenger?
well,
I bet you it was Bellinger.
It was not, it was.
It was Bellinger. It was Bellinger. Everybody quit trying to protect Bellinger.
it was Ballinger.
It was Bellinger. Until he fesses up on that. The court calls the case. People versus Piyush Singh.
And good morning, Your Honor. Sarah Kraus. I'm standing in for the attorney of record, Gabi Silver, for Piyush Singh, who is present in your courtroom. Mr. Singh, can you state your name for the court, please?
Piyush Singh?
All right. And you have no objection. Are you with the same firm, counsel, or no?
I am.
Okay, very good. Then I don't have to ask that. Very good. Oh, sad. Hold on. Okay. I just took his play. Kick him out. Okay, good. All right. What are we doing on this?
Judge, at this time, we are looking to set for a preliminary examination date.
All right. Is all discovery complete?
Up to this point, as well as it can be, Judge. We just received a search warrant that they were going to be downloading some of Mr. Singh's electronics. I don't think that'll be ready anytime soon, so we're ready to set for the exam.
Would people have their witnesses available on the 21st? Preliminary examination in person, January 21st, 2025. 9 a.m. before Judge Moore.
And Judge, Mr. Singh would like me to address his bond again briefly, if I could.
Yes, go ahead.
Judge, in addition to what I've argued previously, Mr. Singh has currently been in custody for about 45 days. He has no criminal history. He does have family here from India right now. They cannot stay for a long period of time due to the visa status. And he's also the sole member of his family who can provide in the United States. So I am asking for at least a bond reduction at this time, Judge.
Any response from the people?
First off, as Ms. Wisniewski argued last time, we would oppose any bond reductions at this time. This, as you remember, Your Honor, is an offense which the defendant is charged with 2 counts of criminal sexual conduct, 1 count of other counts bodily harm, in which the defendant forced the victim to her apartment, slapping her in the face, refused to allow her to leave, threatening her, otherwise he would hurt her, took the victim into her car, smashed a plastic trash can on her head, and hit her with his hand until it was aching. Took the victim to the defendant's apartment and continued to assault her, beat her, hit clips, biting her, forced the victim to perform oral sex on him while filming it, and then threatening to send it to others. We would object any bond reductions at this time, given the severity of the charges and threats to the victim.
Motion for bond reductions denied at this time. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Mondays. So we will continue this next week. I mean, it's like a 3-hour. I try to keep my live streams within 2 hours. You know, I'm going to try to keep it within 2 hours. We will continue these cases next Tuesday. If you like the content that's on this channel and you're not a subscriber to this channel, please consider subscribing to this channel. By subscribing to this channel, you are helping to build a wonderful community here and a wonderful platform. I want to thank all the new subscribers to this channel. Thank you for your support of my little channel. Yeah, I got one from Miami-Dade that's 6 hours long. So I'm probably going to break it up into 2 hour. Yeah. In the miscellaneous cases stuff. Yeah, I try to keep it within 2 hours. And I think after that, I'm starting to fall asleep sitting here. But I will see you tomorrow. Tomorrow is Judge Stephanie Boyd. She's interesting. So I'm going to call this court is adjourned until tomorrow at 3:00 p.m. You all have a wonderful evening. I will see you guys tomorrow. Ta-ta, ciao, ciao. And for God's sakes, try to behave yourselves as much as you can. I'll see you guys tomorrow. Like I said, I try to keep it within 2 hours. And I think after a certain time, people start losing interest in it. So you all have a wonderful evening, and I'll see you again tomorrow.
Never give up on this heart of mine. Put it back together every single time.